My lords would find it at page 128.
Yes.
Now, this is appointment of the governor, and this would, I'm sorry. So this would have tremendous bearing for your lordship's consideration, because the concept which is going on, that the
ये रखिए.
what is the significance and sanctity attached to the office of the governor? Lord, that we come to know from the Constituent Assembly debates. Lord, it's not, my lord, an asylum for retired politicians, as, my lord, we understand. It has its own sanctity. And, my lord, the framers of the Constitution have debated on it, that why we need governor, why we need governors with the powers which we are going to confer upon it, and the federalism which we have adopted, as against, my lord, the absolute federalism in United States, where each state or province has its own constitution, has its own Supreme Court, has its own, my lord, way of governance. We have not adopted that.
Even dual citizenship.
The dual citizenship. So, my lord, they have examined that center will have to play a role in the governance of the provinces, which is now states, and that is how, my lord, the position of governor is conceived. Lord, please have a look at page 128. Lord, section 46 is the perimateria provision, or, my lord, if I may say, the precursor to the present 155, where the governors were appointed. Lord, page 128 bottom, Government of Bengal, Madras and Bombay. The presidencies of Fort William in Bengal, Fort St. George and Bombay are subject to the provisions of this act, governed by the governors in council of those presidencies respectively, and the two former presidencies are in this act referred to as the presidencies of Bengal and Madras. Then, my lord, comes 35 Act. Lord, initially the idea was that the governor should also be an elected person, so that he also wields the same democratic sanctity, and which is rejected by the framers of the Constitution. I'll show that, my lord. Section 48, Lord, 1935 Act, again, my lord, the colonial era act. The governor of a province is appointed by His Majesty by a commission under the Royal Sign Manual. The provisions of the third schedule to, my lord, not relevant. Now, my lord, draft constitution, my lord, which was prepared by Mr. Rao, the governor of a province shall be elected by direct vote of all persons who have the right to vote at a general election for the legislative assembly of the province. My lord, Dr. Rao introduced the concept of governor being an elected person. Then, my lord, the committee chaired by Ambedkarji, my lord, again, my lord, provided for election. The governor of a state shall be elected by direct vote of all persons who have the right to vote at a general election for the legislative assembly in the state. So his election would be confined to that particular state. Then, my lord, the drafting committee gives a second option for consideration. An alternative is given. That is, my lord, this. The governor of the state shall be appointed by the president by warrant under his hand and seal from a panel of 4 candidates to be elected by the members of legislative assembly of the state, or where there is a legislative council in the state, by all the members of legislative assembly and of the legislative council of the state assembled at a joint meeting in accordance with the system of proportionate representation by means of single transferable vote, and the voting at such election shall be by secret ballot. So they were visionaries. They gave 2 options, appointment or election. Appointment, my lord, again by indirect way of election only. Now, my lord, please see the debate. My lord, at page 130 it starts. The Honorable President says, as regards this, honorable members will see that there are 2 alternatives suggested by the drafting committee. The amendments are referring to either the one or the other alternative. So I think the best way is to take an amendment in favor of one of the alternatives, and if then is accepted, then all other amendments relating to the alternative drop automatically. We take 2006, and this is and if this is carried, then we go to the second. 2006 is the number of that amendment.
Number of them.
Yes. Then Malad Ghanshyam Singh Gupta. Sir, I suggest this. The amendments, of course, may be taken, but first we might form our opinion as to whether we want the first or second alternative, so that if we want the first alternative, then the amendment. It would come, my lord, in kindly bear with. Then, my lord, Sri Brajeshwar Prasad, my lord, this is important. For my lord, he suggests that for Article 131, the following be substituted. Governor of a state shall be appointed by the president by warrant under his hand and seal. He said no election, whether as per alternative 1 or alternative 2. And the reason or the justification, my lord, he places before the assembly. The great merit of this amendment, which stands in the name of the 5 or 6 member of this house, is that it lays down a simpler procedure than the prescribed either in the article or in the alternative suggested by the drafting committee. I feel, sir, that in the interest of all India unity and with a view to encouraging centripetal tendencies, Lord, that is a tendency, my lord, to my lord,
Stronger.
Unification,
Stronger center.
the strong cohesion, my lord, if I have used policies, tendencies, it is necessary that the authority of the government of India should be maintained intact over the provinces. To say that the president may nominate from a panel of names really means restricting the choice of president. It gives power into the hands of the legislature. It is necessary, sir, that the president should be free from the influence of the legislator. I feel that the governor may be one from the province or from another province. Personally, I feel that the man from a province should not be appointed in the same province because it gives encouragement for vociferous tendencies. So, my lord, that tendencies, my lord, internal fixed, etc., etc. So I say that choice of the president should be unrestricted and unfettered. Sir, I have nothing more to add. This is a simple proposition and I commend it for acceptance of the House. Then Alladi Krishna Swami Iyer. Sir, in view of the decision that was reached some 2 years ago and in view of the fact that I feel convinced that only right course, taking all the circumstances into consideration, is to accept the amendment of Mr. Brajeshwar Prasad. I should like to say a few words in support of the amendment. In the consideration of this question, the main points to be remembered are that in SM, this has accepted the introduction of responsible government in difference, that the governor is merely a constitutional head of the province and the real executive power had been vested in ministry responsible to the lower house in the different states. No dispute or difficulty. The real power vests in the elected people who are elected by the legislators, by the people of that state as legislators. The question for consideration before this house is whether, under these circumstances, there is any point in going through an expensive and elaborate machinery of election based upon universal suffrage. After giving my best consideration to the various proposals put forward, 1, of choice of governor on the basis of universal suffrage, 2, of election of the governor by a majority of lower house or of both houses, whether on the principle of proportionate representation or otherwise, 3rd, of a selection of a panel by the lower house in the state from which the choice, the lower house is Lok Sabha, not legislative council, but legislative assembly, wherever there is any. Choice is to be made by the president of the union, or 4, if appointment by the president in consultation with the cabinet. I feel that the wisest course to adopt is the last one. If the governor is properly functioning as the constitutional head, the expenses involved in going through the process of election is out of all proportion to the powers vested in the governor under the constitution. There is also the danger of governor who has been elected by the people at large getting into a clash with the premier. Well, that is the chief minister of the state.
Two power centers.
Yes, two power centers, my lord. Uh, and the cabinet responsible to the legislature, which itself has been elected on the basis of universal suffrage. Again, the election itself, under modern conditions, will have to be fought out on a party ticket. The fact is that even at or during the elections, the party will have to rally round a leader who will presumably be the future premier, the chief minister of the province. Is the rallying to be round the governor's name or premier's name? In the normal working of the government, also there is a danger of a clash between minister and the governor, whereas the whole basis of the constitutional structure we are erecting depends upon the harmony between the legislature and the executive, and between the executive and the formal head of the government. There is no correspondence between the governor of a state in United States of America and governor under our constitution. In the case of a governor of a state under United States, the real and substantial executive power is vested in the governor. There is a distinct separation between the executive and the legislature in the United States. A proper analogy has to be sought for the Constitution of Canada, where a responsible governor obtains. In Canada, the lieutenant governor of each province is appointed by the governor general, that is, by the governor general on the advice of the cabinet, similar like India, my lords. There are many features of resemblance and similarity between the Canadian Constitution and our Constitution, which, by some critics, has been considered to be quasi-federal. The system, in the main, we have accepted is the principle of responsible government obtaining in the dominions or in different parts of the Commonwealth. Nowhere does the system of election of governor exist where the institution of responsible government is the main feature of the Constitution. In the normal working of the Constitution, I have no doubt that convention will grow up of the government of India consulting the provincial cabinet in the election of the governor. If the choice is left to the president and his cabinet, the president may, in conceivable circumstances, with due regard to the conditions of the province, choose a person of undoubted ability and position in public life who at the same time has not been mixed up in the provincial party struggle or factions, is not a part of the local state politics. But today, it appears to be very obvious to us. But kindly visualize the vision of the framers of the Constitution.
But then whether have we lived up to the vision?
Yes,
If in the first paragraph,
yes,
they said that there would be a harmony between the governor
yes.
and the
No, I'm slightly on a different.
and the ministry.
Yes,
And the second part is, in the normal working of the constitution, a convention would be developed that the provincial government would be consulted while appointing
I'm
the
on a
governors.
different point. But deviations or, my lord, some exceptional situations, my lord, may not guide your lordships in interpreting the Constitution.
So you are relying on this.
The limited point, my lord, there is something further. There is
You are
something.
entitled to rely on the debates in the Constitution Assembly, no doubt. But then whether the expectations that were
No, my lord, kindly,
expressed.
I stopped at a wrong stage, maybe. But the point I was.
or rather we stopped at the wrong stage.
No, my lord. The real point, my lord, I was trying to make is divorce the facts. That look at the vision of those, my lord, who were discussing this in 1947. And they could visualize these are the problems which will arise if a person is to be elected. Or
There would be two power centers.
two power centers.
One the chief minister elected by the majority of the legislators, and the governor who is directly elected.
Directly elected.
And then the system that we have accepted is the government responsible to the legislature.
Correct. Government, the cabinet is answerable and responsible to the cabinet. That,
Cabinet is responsible
to the legislature. The cabinet is answerable to and accountable to the legislature. Well, thereafter, the bold part. The central fact to be remembered is that the governor is to be constitutional head, a sagacious counselor, and advisor to the ministry. The governor chosen by the government of India, presumably with the consent of the provincial government, is likely to discharge his functions better than one who is elected on a political party ticket by province as a whole based on universal suffrage. Now, my lord, Pandit Jawaharlal Nehru, Lord, says this, my lord. Sir, this debate has already elicited so many speeches that probably every conceivable argument for and against this proposal has been placed before this court. I do not know what I can add to it. My lord, kindly come to, my lord, the bold part. There was the Union Powers Committee, my lord, headed by the Nehruji. There was the Provincial Model Constitution Committee headed by Lord Sardar Patel, of which my colleague, the Deputy Prime Minister, was the chairman. After all these considerations and discussions, those committees felt that a certain change was desirable. Thus, even those like Sardar Patel, who themselves put this forward in this house, the other view, feel that the change would be desirable. This was the flexibility of Sardar Patel, my lord. He chaired the provincial committee, took a particular view, and thereafter takes the holistic view and say that some change is desirable. Now, the reasons for this have been stated before the House, and I need not go into them, except to say that I myself originally was not very definite, if I may say so, in my mind as to which would be the preferable course. I preferred something, but not to the extent of considering it as absolutely necessary. But the more I thought about it, the more I conferred with others and discussed with them, the more I felt that from almost every point of view, this proposal that is moved of a nominated governor in the present context of the constitution was not only desirable from practical point of view, but from democratic point of view, uh, too, it was desirable and worthwhile. My lord, now I can skip that, my lord, and kindly come to the bold part. My lord, I have, this is the way, my lord, I generally make it bold so that the relevant part is before your lordships, but we don't consume your lordships' time in reading them. And I must tell your lordships, my lord, I have selected passages from the Constituent Assembly debates which are relevant according to me for deciding this issue by your lordships. There are other debates also on these subjects. Entire debate is placed in volume 4. If your lordships would like, 4.2, my lord, if your lordships would like to go through it. But these are the relevant debates, my lord, from the standpoint of the issues which your lordships are advising us, my lord. But on the whole, it probably would be desirable to have people from outside, eminent people, sometimes people who have not taken too great a part in politics. Politicians would probably like a more active domain for their activities, but there may be an eminent educationist or persons eminent in other walks of life who would naturally, while cooperating fully with the government and carrying out the policy of the government, at any rate, helping in every way so that the policy might be carried out, he would themselves represent before the public someone slightly above the party and thereby in fact help that government more than if he was considered as a part of the party machine. I do submit that there is really a more democratic procedure than the other procedure, in the sense that the latter would not make the democratic machine work smoothly. Then Dr. Ambedkar, my lords. Yes. My lord, the first part of the Dr. Ambedkar ji is only, my lord, the description or a paraphrasing of what has happened. The second part would be relevant, my lord. Well, that power, your lordship gets, my lord. Well, that power an elected or a nominated governor will have, if he happens to call the wrong person to form a ministry, he will soon find to his cost that he has made a wrong choice. That is not a thing that could be avoided by having an elected governor. Such a governor may have a friend of his choice whom he can call in to form the ministry, and that issue can be settled by the House itself by a motion of no confidence or confidence. But that is not the aspect of the question which is material. The aspect of the question which is material is the governor going to have any power of interference in the working of a ministry which is composed of a majority in local legislature? If that governor has no power of interference in the internal administration of a ministry, which has a majority, then it seems to me that the question whether he is nominated or elected is wholly immaterial. That is the way I look at it. And I want to tell the House that in coming to their decision, they should not bother them more or less academic question whether governor has to be nominated or to be elected. They should bear in mind this question: what are the powers which the governor is going to be endowed? That matter, I submit, is not before us today. We shall take it up at a later stage when we come to question of Article 175 and 188. Please note there, my lord, in your lordship's note, 175 is the draft article, which is Article 200 today. And 188 is emergency powers, my lord, which are not, which we are not
Not concerned at this stage.
no, not concerned. And probably by amendment or the addition of some other clauses which would give him powers. The House should be careful and watchful of these new sections that will be placed before them at a later stage. But today it seems to me, if the Constitution remains in principle the same as we intend that it should be, the governor should be a purely constitutional governor with not power of interference in the administration of the province, then it seems to me quite immaterial whether he is nominated or elected. Now, my lord, what is accepted is 131 draft article. The governor of the state shall be appointed by the president by warrant under his hand and seal. My lord, both the alternatives were given up, and
third,
Vijeshwar Prasad's amendment that he should be appointed by the president, nothing more, nothing less, should be there. So far as his powers are concerned, we will consider when we consider present article 200, and I'll be able to show that this wish, desire, and Lord, what was in mind of the constitutional framers did reflect in Article 200, that he would have only those powers which are conferred and nothing more, maintaining supremacy of the elected wing. My lord, I'll come to that, my lord. Please, now, my lord, come to next page, Article 163. Page 134, Article 163. My lord, it is in pink color.
Yes.
Your lordship gets it. My lord, this green color final draft of the Constitution is, my lord, same, which I have read, my lord, therefore I am not reading it. The color is, my lord, there is some legend, my lord, green is the final thing, etc. At my age, my lord, I can be colorful only on paper.
We agree to disagree.
He's not telling you the entire truth.
No, but that's what I said. We agree to disagree.
Yes. Lord, 163. Lord, what was 1919 Act? Lord, I have quoted, but what is bold is, my lord, relevant for the present purpose. For completeness, I have quoted this whole. 3. In relation to transferred subjects. My lord, when the assembly talks about transferred subjects, it means subjects allotted to state. List 2. 7 schedule list 2. Present. The entries may have changed, but transferred subject would mean the state list, where legislature has the power or competence to legislate. In relation to transferred subjects, the governor shall be guided by the advice of his ministers, unless he sees sufficient cause to dissent from their opinion, in which case he may require action to be taken otherwise than in accordance with that advice, provided that rules may be made under the principal act or the temporary administration of a transferred subject where, in case of emergency, owing to a vacancy, there is no minister in charge of the subject by such authority and such manner as may be prescribed by the rules. Then kindly come to, my lord, what was suggested, what was in 1935. My lord, something similar, but please see 50 subsection 2. I'll read, my lord, 1 also, because here the governor's discretion comes. Well, your lordships have seen yesterday, the president is not left with any discretion after 1919 Act till Article 111 as it stands today. I'm sorry, 75, which it stands today. 111 is a power of assent. But appointment is solely guided by the aid and advice of the Council of Ministers. In case of governor, my lord, the situation was different. The discretion continued throughout, but the discretion came to be circumscribed by use of words which were very consciously used. Lord, please see Council of Ministers in 1935. There shall be a council of ministers to aid, counsel of, and advise the governor in the exercise of his functions, ministers except in so far as he is by or under this act required to exercise his functions or any of them in his discretion, provided that nothing in this subsection shall be constrained as preventing the governor from exercising his individual judgment in any case, whether whereby or under this act he is required to do so. The governor in his discretion, please see the minute, may preside at the meeting of council of ministers if any question arises whether any matter is or is not a matter as respects which the governor is by or under this act required to act in his discretion or to exercise his individual judgment, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion or ought not to have exercised his individual judgment. My lord, kindly note here, my lord, and park that contention, my lord, for a subsequent thing. Two things. If he grants assent, can it be subject to the challenge? If he refuses to grant assent, both, my lord, were immune from the judicial review. Now, draft constitution, my lord, prepared by the constitutional advisor, Mr. Rao. There shall be a council of ministers with the prime minister at the head to aid and advise. Lord, even the provinces had prime minister. Lord, this, when we use prime minister, it was present day chief minister. There shall be council of ministers with the prime minister at the head to aid and advise the governor in exercise of his functions, except in so far as he is by or under this constitution required to exercise his functions or any of them in his discretion. If any question arises whether any matter is or so and so, my lord, same that should not be called in question. Now, my lord, the draft prepared by the drafting committee. There shall be a council of ministers with the chief minister. Now, prime minister becomes the chief minister, my lord. Only nomenclature changes, my lord. Because there was no prime minister in 1935, the governor general was the whole and all, my lord, answerable to the crown. Chief minister at the head to aid and advise the governor in exercise of his functions, except insofar as he is by or under the constitution required to exercise his functions or any of them in his discretion. If any question arises whether any matter is or is not a matter as respect, not same, whether he exercises his discretion rightly, wrongly, cannot be gone into. That is, my lord. Now I come to, my lord, the Constituent Assembly debate on this. And thereafter, my lord, the last debate I will read would be Article 200 and 201. Thereafter, my lord, the submissions start, but your lordships must have, my lord, the background in which these provisions were drafted and formulated, the manner in which they were formulated, what was conceived. My lord, H.V. Kamath. Mr. President, sir, I move that in clause 1 of Article 143, the words, except in so far as he is by or under this constitution required to exercise his function or any of them in his discretion, be deleted. Lord, Mr. H.V. Kamath has always supported the provincial supremacy over central supremacy. He was proponent of that. He may have some personal equations also, my lord, and he always used to object. But this was his, lord, idea of the constitution. If this amendment was accepted,
Influenced by the American system.
Highly influenced, my lord, by the Americans. Some of, my lord, that tendency and trait, my lord, continues even till date. We still believe in the American Constitution and apply it, my lord, in the context of Indian Constitution also. And that, my lord, sometimes results into laying down the law, my lord, which creates more complications than solving them. Sir, it appears from the reading of this clause that the Government of India Act 1935 has been copied more or less blindly without mature consideration. Well, this is kind of a personal affront to Dr. Ambedkar, that you have copied something without applying your mind. There is no strong or valid reason for giving the governor more authority, either in his discretion or otherwise, vis-a-vis his ministers, than has been given to the president in relation to his ministers. If we turn to Article 61(1), we find it reads as follows: there shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his function. When you, sir, raised a very important issue the other day, Dr. Ambedkar clarified that his clause by saying that the president is bound to accept the advice of his ministers in the exercise of all his functions. But here, Article 143 vests certain discretionary powers in the governor, and to me it seems that even as it was bad enough. But now, after having amended Article 131 regarding election of the governor and accepted nominated governors, it would be wrong in principle and contrary to the tenets and principles of constitutional government which you are going to build in this country. It would be wrong, I say, to vest governor with these additional powers, namely discretionary powers. I feel that no departure from the principle of constitutional government should be favored except for the reason of emergency, and these discretionary powers must be done away with. I hope this amendment of mine will commend itself to the House. I move, sir. Then, my lord, Mr. Krishnamachari, my lord, who generally echoes the views of Dr. Ambedkar.
No, both of them were, Mr. Krishnamachari was also
Members of the drafting committee. And it was, my lord,
most of the replies to the amendments are either replied by Dr. Ambedkar or by
T.T. Krishnamachari. Your lordship, sorry. I'm grateful. Mr. President, I'm afraid I'll have to oppose the amendment moved by my honorable friend, Mr. Kamath, only for the reason that he has not understood the scope of the article clearly and his amendment arises out of misapprehension. He again gives it back, my lord, in a polite language. Sir, it is no doubt true that certain words from this article may be removed, namely those which refer to the exercise by the governor of his functions, where he has to use his discretion irrespective of the advice tendered by his ministers. Actually, I think this is more by way of a safeguard because there are specific provisions in this draft constitution which occur subsequently where the governor is empowered to act in his discretion irrespective of the advice tendered by his council of ministers. There are two ways of formulating the idea underlying it. One is to make a mention of this exception in this Article 143 and enumerating the specific power of the governor where he can exercise his discretion in the articles that occur subsequently, or to leave out any mention of this power here and only state it in the appropriate article. The former method has been followed. Here, the general proposition is stated that the governor has normally to act on the advice of the ministers, except insofar as the exercise of his discretion covered by those articles in the Constitution in which he is specifically empowered to act in his discretion. So long as there are articles occurring subsequently in the Constitution where he is asked to act in his discretion, which completely cover all cases of departure from the normal practice to which I see my honorable friend Mr. Kamath has no objection. I may refer to Article 188. I see no harm in the provision in this article being as it is. If it happens that this House decides that in all subsequent articles the discretionary power should not be there, as it may conceivably do, this particular provision will be of no use and will fall into desuetude. The point that my honorable friend is trying to make, while he concedes that the discretionary power of the governor can be given under Article 188, well, that is 200. No, I'm sorry, 356. My apologies.
That's emergency.
Emergency.
Proclamation of emergency.
One interesting thing, my lord, an unfortunate thing, when 356 was being drafted by the Constituent Assembly, Mr. Kamath again, my lord, objected to that central government cannot be conferred power.
So Kamath was not in the drafting committee.
No, in the
When
constituent,
it was debated in the constitution.
when it was debated in the constitution, he objected that central government should not have the power to impose precedence rule, and therefore Article 356 should not be there. To salvage the situation, my lord, it seems Dr. Ambedkar ji says very wisely that I hope and trust that this article would remain a dead letter in the constitution.
Yes,
That-
that's in his speech of 3rd of November 19.
3rd of November, your lordships are right. Your lordship remembers the dates also, my lord, correctly. I am grateful. Now, my lord, after,
Student of law.
my lord, we are all students of law. My lord, unfortunately, in the first government which was formed after the first election under Pandit Nehruji, Lord, the first 356 use came in Kerala state. Nambudripad was the popular leader and he was unseated under Article 356. I'm not going into the politics of it. But that debate was going on, my lord, in the parliament. And debate was whether it should be exercised or not. And Mr. Kamath, my lord, made one comment which, my lord, I think he should have avoided. He said that when the constitution was being debated in the Constituent Assembly, Dr. Ambedkar said that this article would remain a dead letter word in the constitution. Today, Dr. Ambedkar is dead, but the constitutional provision remains and it is being operated. So possibly he had some personal, my lord, equations. But be that as it may, my lord, we are not concerned with it.
One is entitled to have his one own view.
No, view, my lord, certainly.
He might control of the central government through the governors.
No, he provincialist, that it should be completely immune from any central. All his, my lord, objections are leading to that provinces should be completely independent and like American model. My lord, it was genuinely, maybe as a theory.
Everybody was, we have the constitution assembly consisting of so many people having so many ideas.
Ideas, my lord, and Mr. Kamath was a former ICS officer, resigned and started participating in freedom struggle, and he had contributed a lot, my lord, on his own right, my lord, elected to Lok Sabha. So he was not just a, my lord, troublemaker. He had a very strong view, and maybe some, my lord, we all have, my lord, likes and dislikes. I see no harm in the
On
provision.
Mondays and Fridays, we have 17 Supreme Court.
Lord, if I may say on a lighter side, my lord, 32.
No,
No, that's not true.
On the lighter side. I see no harm in the provisions in this article being as it is.
yes.
If it happens that this House decides that in all the subsequent articles, the discretionary power should not be there, as it may conceivably do, this particular provision will be of no use and will fall into desuetude. The point that my honorable friends is trying to, my lord, he ultimately says that let us wait till the actual conferment of powers in the respective spheres comes. Therefore, the serious objection of Mr. Kamath finds for mention of this exception is pointless. I therefore think that the article had better be passed without any amendment if it is necessary for the House either to limit the discretionary power of the governor or completely to do away with it. It could be done in the article that occurs subsequently where specific mention is made, without which this power that is mentioned here cannot at all be exercised. That is the point I would like to draw the attention of the House to, and I think the article can better be passed as it is. Then Dr. P.S. Deshmukh. Mr. President, Mr. Krishnamachari has clarified the position with regard to this exception, which has been added to clause 1 of Article 143. If the governor is, in fact, going to have a discretionary power, then it is necessary that this clause, which Mr. Kamath seeks to omit, must remain. So first you decide whether he should have discretion or not. What discretion we will define when we deal with other articles. Sir, besides this, I do not know if the drafting committee has deliberately omitted or they are going to provide it at a later stage. And I would like to ask Dr. Ambedkar whether it is not necessary to provide for the governor to preside at the meeting. Malot, that may not be relevant. Malot, kindly turn the page over. Sri Alladi Krishna Swami Iyer, sir, there is really no difference between those who oppose and those who approve the amendment. In the first place, the general principle is laid down in Article 143, namely the principle of ministerial responsibility that the governor in various spheres of executive activity should act on the advice of his ministers. Then the article goes on to provide, except insofar as he is by or under this constitution required to exercise his functions or any of them in his discretion, so long as there are articles in the constitution which enable the governor to act in his discretion, and in certain circumstances it may be to override the cabinet or to refer to the president. This article, as it is framed, is perfectly in order. If later on the House comes to the conclusion that those articles which enable the governor to act in his discretion in specific cases should be deleted, it would be open to revise this article. But so long as there are later articles which permit the governor to act in his discretion and not on ministerial responsibility, the article is as drafted is perfectly in order. The only other question is whether first to make a provision, your options can skip. Now, please come to the bottom. Dr. Ambedkar, my lord, replies, Mr. President, sir, I did not think that it would have been necessary for me to speak and take part in this debate after what my friend Mr. T.T. Krishnamachari had said on this amendment of Mr. Kamath. But as my friend Pandit Kunzuru pointedly asked me the question and demanded a reply, I thought that out of courtesy, I should say a few words. Sir, the main and the crucial question is, should the governor have discretionary powers? It is that question which is the main and the principal question. After we come to some decision on this question, the other question whether the words used in the last part of clause 1 of Article 143, that is present 163, should be retained in that article or should be transferred somewhere else, could be usefully considered. The first thing, therefore, that I propose to do is to devote myself to this question, which, as I said, is the crucial question. It has been said in the course of the debate that the retention of discretionary power in the governor is contrary to responsible government in the provinces. It has also been said that retention of discretionary power in the governor smells of the Government of India Act 1935, which is the main was undemocratic. Now, speaking for myself, I have no doubt in my mind that retention on the vesting of governor with certain discretionary power is in no sense contrary to or in no sense a negation of responsible government. I do not wish to rake up the point because on this point I can very well satisfy the House by reference to provisions in the Constitution of Canada and Constitution of Australia. I do not think anybody in this House would dispute that the Canadian system of government is not fully responsible system of government, nor will anybody in this House challenge that Australian government is not a responsible form of government. Having said that, I would like to read section 55 of the Canadian Constitution, Article 55, where a bill passed by the House of Parliament is presented to the Governor General for the Queen's assent, he shall, according to his discretion and subject to provisions of this Act, either assent thereto in the Queen's name or withhold the Queen's assent or reserve the bill for signification of the Queen's pleasure. Three options. Pandit Hridaynath Kunzuru, may I ask Dr. Ambedkar, when the British North America Act was passed, Dr. B.R., this was kindly a sarcastic question, it seems. The Honorable Dr. Ambedkar, that does not matter at all. The date of the act does not matter. I mean, nearly a century ago. Dr. Mr. Kaman says that you are referring to.
Because I think Canadian Constitution must have been successor of the British North America Act.
Yes, which is 100 years ago. Therefore, he says that you are relying upon something which is 100 years.
Relying on a provision which is a century old.
century old, my lord, but without, while forgetting, I'm nothing turns on that, that a provision which has withstood the test of time for 100 years would not become invalid or not acceptable merely because of the vintage.
That's what Dr. Ambedkar deals in the next
Dr.
paragraph.
Ambedkar says this. This is my reply. The Canadians and Australians have not found it necessary to delete this provision even at this stage. They are quite satisfied that the retention of this provision in Section 55 of the Canadian Act is fully compatible with responsible government. If they had felt that this provision was not compatible with responsible government, they have even today, as dominions, the fullest right to abrogate this provision. Dominions means dominions of the Commonwealth, my lord, under the sovereign. Dominions, the fullest right to abrogate this provision. They have not done so. Therefore, in my reply to Pandit Kunzuru, I can very well say that the Canadians and Australians do not think that such a provision is an infringement on the responsible government. Then Loknath Sharma, on a point of order, sir, are we going to have the status of Canada or Australia? Or are we going to have a federal republican constitution? Then Dr. Ambedkar, I could not follow what he said. If, as I hope, the House is satisfied that the existence of a provision vesting a certain amount of discretion in the governor is not incompatible or inconsistent with responsible government, there can be no dispute that the retention of this clause is desirable and, in my judgment, necessary. The only question that arises is, Pandit Kunzuru, well, Dr. Ambedkar has missed the point of the criticism altogether. The criticism is not that in Article 175 some powers might not be given to the governor. The criticism is against vesting the governor with certain discretionary powers of a great nature in the article under consideration. Dr. Ambedkar, I think he has misread the article. I'm sorry I do not have the draft constitution with me, except insofar as he is by or under this constitution. Those are the words. If the words were except whenever he thinks that he should exercise this power of discretion against the
It
wishes,
is implied that wherever the subsequent articles
provides,
provide for a discretion,
yes,
that power will be restricted only to those
he
articles.
does not leave it to the governor's sole discretion
discretion that
to
he can-
decide where I will be exercising my discretion. That's my lord, Dr. Ambedkar.
Not an unruly horse.
Yes, my lordships are right.
Only wherever in a subsequent article discretion is provided,
Yes,
in those articles, in the discharge of those functions, only he can exercise his discretion and not otherwise.
no, otherwise, my lord, by aid and advice.
Clarified. Where he said, therefore, Article 143 will have to be read in conjunction with some other articles
Which specifically
reserve the
reserve-
power to the governor.
Yes,
It is not a general clause giving the governor power to disregard the advice of ministers in any matter in which he find he ought to disregard.
disregard. Correct.
There, I think, lies the fallacy of the argument of my eminent friend.
A policy of
This
argument
is what T.T. Krishnamacharya also
Qualified that how this power is regulated within the framework of the constitution.
will come further. My lord,
That is what Mr. T.T. Krishnamacharya also said, that even subsequent, when we come to discussion with the subsequent articles, and we find that the vesting of the discretion with the governor is not necessary, then we can have a relook at this article.
Absolutely. That's what, my lord, it means. My lords are right. Now, next page. Therefore, as I said, having stated that there is nothing incompatible with the retention of the discretionary power in the governor in specified cases with the system of responsible government, the only question that arises is, how should we provide for the mention of this discretionary power? It seems to me that there are three ways by which this could be done. One way is to omit the words from Article 143, that is 163 today, as my honorable friend Pandit Kunzuru and other desire, and to add to such articles as 175 or 188, that is 200 and the emergency powers, or such other provisions which the House may hereafter introduce, vesting the governor with discretionary power, saying notwithstanding Article 143, the governor shall have this or that power. The other way would be to say in Article 143 that except as provided in articles so and so, specifically mention Article 175 or whatever they are, But the point I'm trying to submit to the House is that the House cannot escape from mentioning in some manner that the governor shall have discretion. Whether you put it under 163 or 200 later, that's not relevant. The principal question as a principle to be decided is whether governor should be given some discretion or not. And my lord, thereafter 163 retains the discretion. Then, my lord, now the matter which seems to find some kind of favor with my honorable friend Pandit Kunzuru and those who have spoken in the same way is that the word should be omitted from here and should be transferred somewhere else, or that the specific article should be mentioned in Article 143. It seems to me that this is a mere method of drafting. There is no question of substance and no question of principle. I personally myself would be quite willing to amend the last portion of clause 1 of Article 143 if I knew at this stage what are the provisions that this Constituent Assembly proposes to make with regard to vesting of the governor with discretionary power. My difficulty is that we have not yet come either to Article 175 or 188, nor have we exhausted all possibilities of other provisions being made, vesting the governor with discretionary power. If I knew that, I would very readily agree to amend Article 143 and to mention the specific article, but that cannot be done now. Therefore, my submission is that no wrong could be done if the words as they stand in the Article 143 remains as they are. They are certainly not inconsistent. Conferment of discretion.
Is there a revisitation of this debate after the debate of 175 and 188?
No,
Yes.
No, there isn't.
Yes.
it's not there.
There isn't.
Lord,
So
in-
at that time, we didn't have anything like
Lord, in when
impact assessment of a statute. Or as of now,
Your
if
Lordship.
we see the amount of litigation it has thrown by having provisions of this nature, perhaps that could tell us whether the vision was right or not right. Because the validity or correctness of a thought would come by its performance.
How it
Of
operates.
today experience.
how it operates, how it has
Amount of
operated.
litigation it could have thrown, which could perhaps be
My lord,
avoided.
I may
with
make
certainty and
one-
clarity.
Lord, I may make one thing clear. While reading this debate, my lord, it is not my intention to argue and ultimately, my lord, raise a contention that governor has absolute discretion. That's not the purpose of reading this. The purpose of
Your argument is that under this article 163, the power of the governor to exercise his discretion, wherever the subsequent articles reserve the discretion in him, the governor would be entitled to exercise the discretion, and Article 200 is one of such articles where a discretion is provided to the governor.
my lord, by very nature of the article, it is so provided. And I'll, my lord, come to that. And when I read, my lord, Article 200 debates, my lord, that comes out because, my lord, there are, as my lord Justice Nasima rightly says, we understand the constitutional principles based upon how the function, how it has operated, how it has worked. My lord, there are some conventions which are also developed. For example, my lord, 163 says that the governor will act on the aid and advice of the Council of Ministers. Now, my lord, when the first person is to be called to form the government, there is no Council of Ministers. So the governor, by very nature of the act, will have to act on his discretion. My lord, when there is a dispute, which leader has the majority in the House?
We have some experience as to in what manner some of the honorable governors have exercised their discretions, leading to so many litigations.
My lord, I must, my lord, tell your lordships and my lord, put a little word of caution for myself also. My lord, if we go by some example,
We are not going by that.
I understand. No, I am saying something else. Lord, Indian democracy is a mature democracy. There may be aberrations, my lord, on individual cases. But by and large, the democracy under this very constitution has worked very effectively. And that, my lord, I have personally witnessed, my lord, during COVID period. During COVID period, my lord, the Indian democracy and how the center, province, federal balance is envisaged what was at display. Lord, irrespective of the party in power in the center, which was, Lord, NDA, BJP, etc. All state governments ruled by Congress, ruled by communist, everyone, they were on the same page with the Honorable Prime Minister. There was no dispute, difference, and they used to call each other. That's the way democracy works. That you have debate, you have deliberation, you have consultation, you give suggestions, you take suggestions, and everyone was on the same page. Lord, since I was appearing, my lords, I know it for sure that chief ministers of those states, whose chief ministers were very critical, and it was the right to be critical of the center. My lord, they used to call the prime minister at 2 o'clock that this is what we are needing, and there would be a serious problem, and the thing would reach. And my lord, the counter thing also. The government also responded in a matured way, except, my lord, one or two exceptional states. But everyone, my lord, because all these people, my lord, irrespective of the political leanings, they have, my lord, political experience of 30, 40, 50 years. They have that political maturity, my lord, to decide. So, my lord, it would be really hazardous, my lord, to even examine constitutional interpretation based on certain aberrations. There are ambitions, there are, my lord, pitfalls, but that is to be taken care of on a case-to-case basis. One cannot interpret the constitution based on the worst example, because, Lord, hard cases always results into laying down of bad laws. That's, my lord, that's a settled principle throughout all jurisdictions.
If not otherwise, hard cases make good law.
But I would not respond to this. Then Dr. Ambedkar, of course, there is, because we do not want to waste the president with any discretionary power, because the provincial governments are required to work in subordination to the central government. And therefore, in order to see that they do act in subordination to the central government, the governor will reserve certain things in order to give the president the opportunity to see that the rules under which the provincial governments are supposed to act according to the constitution or in subordination to the central government are observed. Please mark this, my lord. This is, my lord, the fundamental foundation of, my lord, the Constituent Assembly. And this is what was the thought, the principle of constitutionalism in the mind of Dr. Ambedkar, that they must be free to take decision, but there must be some level of, Lord, deference to the central government, because we have a quasi-federal constitution. Then H.V. Kamath, will it not be better to specify certain articles in the constitution with, my lord, he continues, my lord, with his objection, my lord. I may skip that. Now, my lord, kindly come to present, my lord. Green is Article 163, which is at present. That normally, I'm paraphrasing, the governor will act in accordance with the aid and advice of the Council of Ministers, and governor must do it. We are not arguing A versus B. I'm assisting the court because we are seeking your lordship's opinion. So I'm just giving what is my reading of the constitution. Governor will have to act on the aid and advice except where he is having discretion, either conferred by the constitutional provisions or by the very nature of the power which he is exercising. Then, my lord, 200 and 201, and this is the last provision which I will bother your lordships with the Constituent Assembly debates, my lord, and then I'll come to other submissions, my lord. Please see Government of India Act 1990. This is very relevant because this is directly in question. This is precursor to Article 200. What are the options available for the governor when a bill is presented to him? Is he supposed to sign it as an automated person, as, my lord, one word which is
The postman.
he's not a postman. That's what, my lord, my effort would be, and that comes out from the constituent debate. The very nature, in the very manner in which Article 200 is couched, the language which is used, it gives him options. And when I am given 3 options, means I have been given discretion to choose one of them. The word discretion being used or not used will make no consequence if I am given 3 options or 4 options. I'll show that. Please come to section 12 of Government of India Act 1919. And this would be relevant, directly relevant for the present purpose. Where a bill has been passed by a local legislative council, the governor, lieutenant governor, or chief commissioner may, instead of declaring that he assents to, or first option, my lord, is granting assent, assents to, or withholds his assent from the bill. Second option, return the bill to the council for reconsideration. Third option, either in whole or in part, together with any amendments which he may recommend, or in cases prescribed by rules under the Principal Act may, and if the rules so require, shall reserve the bill for consideration of the Governor General. That is precedent. So 4 options: assent, withhold, return to the House, or refer it to the Governor General, which is the present day President, for his assent. Where a bill is reserved for the consideration of the Governor General, the following provisions shall apply when it goes to the President in the present terminology. The Governor, Lieutenant Governor, or Chief Commissioner may, at any time within 6 months from the date of reservation of the bill, with the consent of the Governor General, return the bill for further consideration by the Council with a recommendation that the Council shall consider amendments thereto. The President can refer it back. Instead of the Governor choosing, Governor may choose that I will send it to Governor General, then namely the President. He can say that, no, I send it back. B, after any bill so returned has been further considered by the Council, together with any recommendations made by the Governor, Lieutenant Governor, of Chief Commissioner relating thereto, the bill, if reaffirmed with or without amendment, may be again presented to the Governor, Lieutenant Governor, or Chief Commissioner. Any bill reserved for the consideration of the Governor General shall, if assented to by the Governor General within a period of 6 months. Time limit was prescribed by the Act itself for the President equivalent, namely the Governor General, to act. And I'll come to, my lord, that as soon as possible part. That is also, my lord, taken care of. From the date of such reservation become law on due publication of such assent, in the same way as a bill assented to by the Governor, Lieutenant Governor, or the Chief Commissioner, but if not assented to by the Governor General within such period of 6 months, shall lapse. Consequence also provided, time limit stipulated, and consequence provided, meaning thereby the time limit is mandatory, not discretionary, and be of no effect unless before expiration of that period, either one, the bill has been returned by the Governor, Lieutenant Governor, or Chief Commissioner for further consideration by the Council, or in the case of the Council not being in session, a notification has been published of an intention so to return the bill at the commencement of the session. The Governor General may, except where the bill has been reserved for his consideration, instead of assenting to or withholding his assent from any act passed by local legislature, declare that he reserves the act for the signification of his majesty's pleasure. Well, this was a standalone provision because there was someone above the Governor General, the present day President. Here, my lord, President is
There's no one above.
no one above. Assenting to withhold, my lord, therefore, my lord, and I would come to that, my interpretation of the term withhold is that it is not given effect to it. It falls through. That's how the Supreme Court has read. Falls through. And please, my lord, read, my lord, these provisions in this context. Now, 13. Provision for case of failure to pass legislation in Governor's Legislative Council. Where a Governor's Legislative Council has refused leave to introduce or has failed to pass in a form recommended by the Governor any bill relating to a reserved subject, that is, my lord, state list. The governor may certify that the passage of the bill is essential for the discharge of his responsibility for the subject, and thereupon the bill shall, notwithstanding that the council have not considered thereto, be deemed to have passed. There is a deeming provision made by way of a statute. Deeming provision of a bill having been passed can be made either by a statute or by amendment of the constitution. I'll come to that little later, my lord, whether that can be done by a judicial verdict, that's a separate argument. And shall, on signature by the governor, become an act of the local legislature in the form of the bill as originally introduced or proposed to be introduced in the council, etc. My lord, rest of them may not, my lord, assist your lordships. Please come to, my lord, my lord, 72 is the draft bill of the constitutional advisor. And my lord, kindly come to, my lord, first 70, my lord. Assent, this is again 1935 Act. What I read was 1919 Act, now 1935 Act. A bill which has been passed by the provincial legislative assembly, that is, my lord, present day state assembly, or in case of a province having a legislative council, has been passed by both chambers of the provincial legislature, shall be presented to the governor, and the governor, in his discretion, my lord, the other side would harp upon this, that there was a discretion which now no longer exists in Article 200. Therefore, I am highlighting, my lord. In his discretion, shall declare either that one, he assents in his majesty's name to the bill, second, or that he withholds assent therefrom, third, or that he reserves the bill for consideration of the governor general. That is, my lord, president. Provided that the governor may, in his discretion, return the bill. This is the fourth option. Return the bill together with a message requesting that the chamber or chambers will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he may recommend in his message. And when a bill is so returned, the chamber of chambers shall consider it accordingly. It stopped here. So three options, he can straightway say, I withhold, I grant assent. He can say, I withhold the assent, meaning thereby I will show the bill falls through. Third, he may say that no, there is some repugnancy, some violation of fundamental rights, I refer it to the president. And fourth option, in his discretion, he can say that no, it is curable defect in the bill, and therefore I return it with my message that this particular provision is repugnant. There is already a central law occupying the field, and therefore you please reconsider, or even desirably. Instead of 19 years of age, you consider 21 or any such thing, my lord. I'm just not giving hypothetical examples. But four options were available to the governor then. Now, my lord, draft constitution, para 72, when Mr. B.N. Rao, Dr. B.N. Rao, my lord, prepared the draft constitution. A bill which has been passed by the provincial legislative assembly, or in case of a province having the legislative council, has been passed by both houses of the provincial legislature, shall be presented to the governor, and the governor shall declare either that he assents to the bill, one. Yes. (356) doesn't use the word discussion. Yes. But I was reading 147 as suggested by